When you have loved ones or friends who need help handling their daily affairs, whether they are elderly or disabled, relatives or neighbors, and you believe they need a guardian to handle those affairs, and when all other alternatives aren't realistic or have not worked, it often becomes necessary to file what is called an interdiction in the Louisiana court system. In Louisiana, the legal term for a guardianship of an adult is called an interdiction. Your friend or relative is referred to as the potential interdict. The person appointed to be the guardian is called the curator. In addition, the court appoints what is called an undercurator, who has certain oversight duties. Video number 5. What can I expect from the court process?
So you've gone through a process of considering alternatives, and now you've decided that you need to do an interdiction for someone. In other states, that's called a curatorship, or you're appointing someone to be a, quote, guardian of an individual who cannot take care of themselves or can't take care of their business. In Louisiana, that person is referred to as an interdict. One thing that we have to keep in mind is that we're still dealing with a real person. We're using legal terms, but this can be very emotional for people. The person, probably for you, if you're considering this, you're dealing with someone who can no longer take care of themselves. It also can be emotional for the person that's being interdicted if they're capable of even knowing what's going on. So we use legal terms in talking about things like this. We refer to the person as an interdict. We may refer to you as a curator or a petitioner, but we are dealing with real people, and it can be an emotional situation. It's a very serious thing. The law takes it seriously for a good reason. So at this point, you've decided you need to go to court. You're going to have to hire a lawyer and have this person interdicted is the proper term. The person, and we'll refer to them as the interdict at this point because it makes it easier for us as lawyers to talk about it. It may be your mother, it may be your dad, it may be a neighbor, it may be a child with a developmental disability. The essential rules in Louisiana for interdiction will still apply. We're going to assume for these purposes that we're not fighting with anyone. We have interdictions come up quite often where family members are fighting, or there perhaps will be one bad family member trying to take mom's money or take advantage of something. We're not going to get into too much of that, although that is something to consider at times. So for our purposes, we'll consider that everyone is getting along and that they're trying to take care of their loved one, who, for our purposes, are going to be referred to as the interdict. So the first thing you'll have to do is gather a lot of information. By this point, you would have already decided who will be the curator. That's a very important position. It means that you're going to be the person who is in charge of taking care of the interdict and or perhaps taking care of their property. We're going to consider for these points that this is a complete interdiction. In other words, you can have a limited interdiction where you take care of the person's property, but maybe they can take care of themselves. We'll consider that this is just going to be what's referred to as a full interdiction, meaning that you're essentially turning this person into a child again as far as legal rights are concerned. So it's an important thing. You will want to take to the lawyer the information on, first of all, who is involved in this. And let's just assume that you're doing this for your mother, perhaps, who no longer has capacity to take care of herself. If all of your brothers and sisters agree, it's so much easier. It works out better. And from the perspective of a judge, the judge will realize, okay, I don't have anyone trying to do anything bad to this person. Everyone's trying to do the right thing. Those are the best kinds of situations in an interdiction. So what you'll want to do is bring to the lawyer information on everyone's name, the curator's name, and you'll have to have a person who's going to be what's called an undercurator. You're also going to want to talk to a physician. It should be the interdict's physician, and that doctor would be in a position of having to say, okay, this person is my patient, but I've taken care of her for a long time, perhaps, but I have examined her recently and she is no longer capable of taking care of herself or taking care of her business. We will assume for this purpose that she cannot do either one. So that physician then is going to be in a position to be perhaps testifying at court. Quite often, that's a rough situation for the doctor also, because you have to remember a doctor has a relationship with the patient, and that's an important protected relationship. So don't just think that your doctor's being aggravating if they're a little hesitant to do this. It's an important situation for them also. You need to talk to the doctor, see if the doctor is willing to actually come to a courthouse and testify that he or she believes that your mom at this point needs someone to take care of her. There are times where the physician can issue what's called an affidavit. An affidavit is a document that's notarized by a notary, and sometimes if there's agreement among all the people involved in this, and if the judge agrees, you can use an affidavit instead of have the doctor actually have to come to the courthouse. For our purposes, we'll assume that the doctor has to show up. So you've got the petition, you've brought the information to the attorney. The attorney then drafts this thing called a petition for interdiction, and it's essentially a lawsuit. One of the emotional factors of this is that you're essentially filing a lawsuit against the person that you're interdicting. They are going to be served by a deputy. A deputy is supposed to physically touch them with this piece of paper, even if they do not understand what's on the paper. Attached to that citation will be this petition for interdiction, and it's going to lay out in words why you're referred to as the petitioner, and you may also be the person who wants to be a curator, think that the interdict can no longer take care of him or herself. So keep in mind that person is going to be reading things that you're saying about them, so it can be emotional. You may want to let them know ahead of time, hey mom, there's a deputy coming to see you. We got to go through this because the lawyer said we have to. You can always blame it on the lawyer, but we've got to get all this set up, and we're trying to get set so you don't have to worry about going to the bank. We can get you to your doctor and we can take care of things for you. Most of the time, there's not a disagreement. If there is a disagreement with that person, you just have to go through more of the process. You also bring to the lawyer, while they're preparing that petition, asset and liability information. In other words, if there's a lot of debt, you bring the credit card information to them. You can bring them information on the house. If your parent or the person being interdicted has assets in an investment account, you bring that to the lawyer, and the lawyer is required to draft something called a detailed descriptive list. And what that is a list. Starting at the top, it lists the assets, and next it goes to the liabilities, and then it's got a net. And what that shows the judge is that, look, this person has these things. We're asking that this particular person be appointed curator to take care of not only these things, but also the person themselves. In other words, we can take them to the doctor, we can lock the door and make sure they can't wander outside at night and get hurt. We're going to be in charge of everything. The other document that is filed along with the petition is something called an oath. And you will be required to sign an oath if you're going to be the curator after the judge has said, okay, I will grant the interdiction, I'm appointing you as curator, therefore you sign an oath. And it says that you're going to properly take care of the business and act as curator under the law. As you would have heard in another segment of these videos, you have to follow the law and you have a responsibility to take care of this person's assets appropriately. Once the petition's filed, once the interdict is served with the papers, there's an order attached to that petition. That order goes to the judge's office. The judge is then going to sign that order, and on it is going to be a blank, typically, and the blank is going to have a place for the name to appoint a lawyer to represent the interdict. So this is not something that you do without, I don't want to call it a fight, but it is something where there are two sides, because the law requires that the person being interdicted has a lawyer to protect their rights. Because like we said a minute ago, you're essentially taking away their rights and turning them into a child as far as ability to take care of business or do other things. Typically, a judge will appoint someone that they're familiar with, someone that they trust, and someone that knows how to do this. Those people are not your enemy. They're not out there to fight or cause a problem, but they are there. They have a legal duty to make sure that your lawyer and that you follow the proper procedure in the interdiction and that the interdict is protected. They're not an interdict yet. They're until this is granted. So that lawyer has a job to do. Typically what happens is that your lawyer and the court-appointed lawyer talk to each other. Lawyers do talk to each other. It's not always a fight. And quite a few agreements can be made up front. One thing that is required, and you may want to let your loved one know about that, is that this lawyer is required to go see the person. They can't just talk to them on the phone or read a set of medical records that you may give them. They're supposed to actually go to the location, go to the hospital, go to the nursing home. Even if the person is comatose, they're supposed to go see them. You may have a situation with a person who's comatose. They may not be able to actually get into, for example, an ICU. They're supposed to see them and at least talk to someone, say, yes, this person cannot speak, cannot communicate or anything. Otherwise, they have to visit with the person being interdicted. That appointed lawyer is then going to do a report, and the judge is going to want to know what that appointed lawyer has to say about the person being interdicted. Your lawyer and the appointed lawyer may also agree that the doctor does not have to show up live to testify. The judge may still want the doctor there live. So that's another part of this process, and typically you would want a doctor there, especially if it's a little bit uncertain. Let's assume we're not dealing with a comatose person. Let's assume we're dealing with someone who, for example, has started wandering out at night. She gets lost. The police have brought her back to her house. Quite obviously needs assistance, but she's just not quite agreeing to being interdicted at this point. She doesn't even know what the word means, but you're still her child and she tells you what to do, not the opposite. So you have these two people talking, the lawyers, and they discuss what's going on. The judge has the order. The judge and the clerk of court have calendars, and they're going to set a date for the hearing. For our purposes, we're going to assume that this is what's called a permanent interdiction. So the hearing may be 30 days away, 45 days away. There are situations which we do not need to get into here, but if it's an emergency situation where some decision has to be made, there's a provision for that in the law called a temporary interdiction. And you can get something done on those very quickly. But we'll skip over that now, but that is part of the process if it's needed. So let's say the order is signed, you file the petition, the order is signed, and then what your family member or the interdict to be is actually served with is a citation, a copy of the petition, and a copy of that order signed by the judge saying, okay, you, person being interdicted, have essentially been sued. So you need to watch out for that language. You may want to prepare them for that. This person's been appointed to represent the person being interdicted, and there is a hearing set for this day, meaning there's a court date, and it's like a trial. It is essentially a trial. Your lawyers then need to get together, your lawyer and the court-appointed lawyer, and quite often someone doesn't have that day available, or perhaps the person being interdicted has a surgery that day. So there are issues that come up. Things can be worked out on that, but there will be a date set for a hearing. So let's assume we're past that. The hearing's date, and it's time for you to go to trial. It will typically be in the morning, usually, not always. If you've never been to the courthouse, it's intimidating. Sometimes I think they're designed on purpose to be intimidating. Let's assume that the person being interdicted is in fact going to go to the hearing. They have every right to do that. In fact, if they're not going to be at the hearing, your attorney needs to be able to explain why not. Perhaps they're in a bed, they're bedridden, and they cannot go anywhere. Or they're dangerous. Things like that happen. But let's assume they're coming this time. Things to consider are, for example, first of all, how are you going to get them there? If they're in a wheelchair, some courthouses, you got to go in a side door where there's an elevator. So you may want to talk to your lawyer about those kind of things because you're going to be nervous. It's very emotional. The person you're bringing with you to interdict is going to be very nervous and emotional. So let them know ahead of time, at least you know which door to go into to the courthouse. Do not bring a pocket knife with you or anything sharp. That just adds to the anxiety, if you would, because you do have to go through a metal detector. Some people forget that. A lot of people forget it. Also, cell phones are a big deal. Typically, it may even be better to just leave your cell phone in your car or your truck. Some courthouses do allow them, but you have to make sure they're off. I've had a judge before say or threaten to take away the cell phone and fine someone $1,000 because their cell phone rings. So that is an important thing, and you don't want it brought up at the wrong time during something this emotional and this important. So you're going into the hearing. You go through the doors of the courthouse. Typically, if you're the one interdicting the person, they may be walking with you. They know you, your mom trusts you, and you're the one who has filed a suit to have her interdicted. So it can be emotional. It's odd a little bit because you're the person and you're against her, but she's walking with you probably because she trusts you and she's your mother. So it can be a strange situation emotionally. You go into the courthouse, and all the courthouses have typically is like a little fence, but it has a rail, and you're actually going to be on the side of the rail where the judge is as a witness typically. Family members can come. Quite often a judge will clear the courtroom, and they'll have a deputy in there that's called a bailiff, and the bailiff sometimes, because of personal issues are brought up, sometimes they'll clear the courtroom, meaning it's not going to be a crowd. Sometimes there will be other people there. Nonetheless, you go into the courtroom and you get a seat. Your mother in this situation might want to sit by you. Maybe not. She might be mad at you because you've drug her into a courthouse and she knows that you sued her. And that happens too. So they'll sit on the other side, and sometimes they'll start talking when they shouldn't talk. Because remember, we're dealing with someone that's lost a lot of their capacity already. So you'll have those issues that come up, and guess what? The bailiffs are used to it. The deputies know how to handle things like that. The judges have seen it all usually. But just be prepared for those kind of things. Your lawyer gets to go first. Since if you're the one who filed this petition for interdiction, you go first. So your lawyer stands up. First the judge says, okay, everybody make their appearance. Your lawyer say his name or her name. Then the other lawyer, the court-appointed lawyer, says his or her name and who they're representing. The judge is going to look out there and say, okay, who's here? Well, Miss So-and-so that we're interdicting is here. The curator's here. And the judge says, okay, let's go. So then your lawyer gets to call the first witness. Typically, you're going to want to call the doctor because they're getting paid to be there and they need to be back in their clinic. So if the doctor's going to be a witness, instead of an affidavit, you call the doctor to the witness stand. That can be a little bit touchy because his patient is sitting in the room sometimes and the doctor's fixing to say something about him or her that she may not appreciate. So that can be a touchy situation at times. Other times, if it's an affidavit, your lawyer will just say something to the judge to the effect of, Judge, I'd like to offer introduce into evidence this affidavit of Dr. So-and-so. And the other attorney says, yes, Your Honor, we agree. And the judge is okay with that, fine. On the other hand, the judge may say, no, I want to hear the doctor talk myself. Your lawyer will ask the doctor questions. Doctor, do you believe that Mrs. So-and-so has capacity to live by herself? Is there a less restrictive means for her to get along? Is she capable of taking care of her banking? Is she dangerous to herself at this point? The lawyer can try to make these questions, to use the term perhaps gentle, if the person is in the room, to not be offensive. Sometimes you got to push it a little bit because the judge has to hear the reason as to why this person cannot take care of themselves anymore. So after your doctor testifies, then the other attorney has a right to ask that doctor. It's a cross-examination. That person is supposed to ask the doctor some questions like, Doctor, did you personally examine Ms. So-and-so? And the doctor has to better say yes or he's in trouble. After that, the judge may even want to ask the doctor a question or two. Typically not, but the judge may. Then the doctor is released, the doctor can leave. The next witness typically would be a family member or perhaps the person being the curator. You want to make this as quick and as easy as you can. Shorter is better than longer with these situations. So you can call that person up. And Judge, I'd like to call as a witness Ms. So-and-so, who's going to be the curator. So that person has to go up through the little gate, up there on the side of the gate where the judge is, and there's a person there called a court reporter that raise your right hand, swear to tell the truth, the whole truth, nothing but the truth, or affirm. So then you're going to sit in the witness stand by the judge or close to the judge, and then your attorney gets to ask you questions. Why are we doing this? Tell us what she's been doing. And you want to have practiced this with your attorney beforehand. It'll be, okay, Mr. So-and-so, tell us, was your mom leaving at night? What happened? Did the police call you one night? Is she paying her bills? No. How do you know? So you get into some of those things. Knowing that your mother may be sitting in there listening to you can be kind of rough. That's something people sometimes don't think about. So you got to be ready for that. The other lawyer then has the ability to ask you questions, and he or she may ask you something like, do you have any experience in doing banking, or do you have a finance background? Are you able to take care of these things for the person? Sometimes the other lawyer won't ask you much, sometimes they will, but it's their job to do it. They're supposed to do it because they're looking out for your mother's rights. After that, you'll be excused as a witness unless the judge wants to ask you some questions. Sometimes the person who's being interdicted wants to testify, or perhaps you need them to testify. As you can imagine, that can be emotional. If the person can walk and get around, they may be asked to go sit in the witness stand, and they will also be sworn in. However, let's say that they're in a wheelchair and they can't get around. Most judges will agree that they'll let them sit where they are. They're still sworn in. The judge has to be able to hear them. They're on a microphone because there's someone recording all of this. That doesn't happen that often, but it can. And if you and your lawyer think it may happen, you may want to talk to your loved one about it. Hey, Mom, you may need to talk and say a few things. That can make it tough for your lawyer because your lawyer at that point has to make sure that the judge understands that that person has some problems, that they're not capable of taking care of themselves, and that they can't take care of their business. After that, and after the last cross-examination, your lawyer is just going to say, Your Honor, I rest. The other side, the court-appointed lawyer, does have a right to put on a case at that point, but typically there's not much. That lawyer may want to call the person being interdicted, may want to call another witness, but usually not. But they have that right to do it if that's needed. Then once it's done, then it's up to the judge. Typically a judge will render a ruling right then from the bench, meaning that the judge has made a decision as to whether or not the person needs to have a curator appointed. And if so, the judge is then given something called a judgment of interdiction. The parties have to have agreed on what it is as far as this is what the judge ruled. The document is given to the judge usually after this because it usually has to be revised somewhat. Sometimes you can have prepared it in advance. And if it reflects what the judge wants, it says, okay, and it's like notice to the world that this person now has been interdicted. This individual has been appointed curator. This individual undercurator. Then there's a paragraph that says, as curator, this person has all of this authority, and it lists what this person can do for the person who's been interdicted. It probably also sets a bond. Sometimes you can have the bond waived. Sets the bond, and then it'll say something to the effect of, after this curator and undercurator have met all the requirements of law, then the clerk of court is to issue something called letters of curatorship. The requirement of law would be posting of a bond, presenting the oath to the clerk of court's office, which means it's filed at the courthouse, and then you have interdicted the person, and you are the curator. The clerk of court then can give you a certified true copy. You'll want more than one, which your lawyer will get for you, of the judgment of interdiction, and you will get from the clerk of court documents, and you'll want several copies that are letters of curatorship, which also list all of your authority and all the power you have. At that point, you're done with the interdiction, hopefully the person that you interdicted still realizes that you care for them. If it's a situation where you required an interdict, they may not remember the interdiction, they may not have been present. Hopefully that works out and everyone realizes that you're trying to do the best for a person that you care a lot for. I know this is a lot of information, but it is a complicated process, and it's complicated for a reason. You're trying to do something very serious. You're taking away the rights of a person, but you're doing it so that that person can be appropriately cared for. For more information, please see the link. Also, certainly thank you for listening.
A supporting PDF document of video number 5 is available at the Governor's Office of Elderly Affairs website, goea.la.gov. For next steps, go to video number 6. What do I report to the court? And what about regained capacity?